Yeah, so today we're going to be talking about the DeLa pipeline and eminent domain specifically for that project, what's happening on the project, what's going to happen when they need your land for the project. Again, my name is Jordan Walker. I'm an attorney with Seaver Walker Paget Law Firm. We are an eminent domain only law firm. We are an eminent domain only law firm that only represents landowners. We do quite a bit of utility work across the country. I personally handled hundreds of pipeline cases myself, but we've done pipeline cases, power line cases, really across the country, and that includes Texas as well. So as a consequence, because we do this so often and in so many different places, we've experienced quite a bit about what happens when a pipeline needs landowners' properties, needs easements for the project. So we've seen how it works. We know what they do, and we know how to respond when they come through and start making offers for your property. I say this at the beginning of our presentations only because sometimes people are a little confused by our letters, but we do not work for the pipeline company. We do not work for DeLa Pipeline. We work for landowners only. A lot of people aren't sure if we're attorneys for DeLa or what we're doing here, but ultimately, what we're trying to do is impart our knowledge and help out landowners if they'd like on their individual cases. Briefly about the project, I just want to talk a little bit about this. DeLa Pipeline, if you're not aware of what it is a really big natural gas pipeline that is stretching across the state of Texas. It ends over in Lake Charles, Louisiana. This is a common route, common path for pipelines, infrastructure, moving oil, natural gas, etc., to the coast. Fairly common route, like I said, but this is a significant pipeline. It's 809 miles in total, and that includes laterals and the length of the pipeline. Moving, of course, from the Delaware Basin to the Lake Charles, Louisiana. How big the pipeline depends on where you are on the project and what they need, but it's probably going to be between 24 to 42 inches. My understanding is they already own some rights on this project. There's already pipeline located, it already pre-existing in a lot of areas, but they are going to need new easement, new pipeline from some landowners as well. And I brought up FERC. It's a cross-state FERC pipeline, and FERC is relevant because FERC, which is the Federal Energy Regulatory Commission, approves these projects, these natural gas intrastate pipeline, or interstate, I should say, natural gas interstate pipelines. These are governed by the Natural Gas Act, which means they are governed federally, which means they require federal approval, and that approval or rejection takes place at the Federal Energy Regulatory Commission. So in other words, in order for this pipeline to become a thing, and in order for it to be constructed and built and put in service, DeLa needs to get approval from FERC before they can build. And they have not received that approval yet. We are in the early stages of the FERC process. We are at a stage called pre-filing, which is before the actual FERC application is submitted for approval. But ultimately, that's the relevance of FERC. They're the ones that are going to determine whether or not this thing can be built. And if it can be built and if they approve it, they will give them DeLa Pipeline eminent domain, federal eminent domain authority through FERC. And that's where the eminent domain comes in, because they will get this, assuming the pipeline is approved, which we are assuming it will be. We're not saying that because we have some sort of knowledge or we're involved in that process specifically. But these projects are by and large generally approved, and not always, but they do have a pretty high success rate. And the objections to these types of pipelines are getting fewer and fewer. So there's not a lot that can be done. Although, if you are interested in fighting the pipeline, the time to fight the pipeline would be at the FERC docket, at the FERC stage of the process. So now would be the time to fight it if you're trying to fight it and raise environmental issues or whatever issues you'd like to raise. That would be the time. Now would be the time to do that, to get involved in that. We are not going to focus on the FERC process. We're going to focus on the eminent domain process. So what happens after they get this FERC authority? Again, assuming they get it as part of this FERC certificate, which is what it is that they receive. This gives them eminent domain authority. And again, we assume they will have it, and we have to assume they will have it, because if you assume they don't have it or won't get it, you're not going to be as prepared as you will if you do. A lot of people, I think, dig their heels in and hope things don't happen, as opposed to recognizing what will and what won't. This is one of those things that I would assume is going to happen. If it were my land that was being affected, I would assume this is going to happen. So I would want to focus my efforts on what I can control as opposed to what I can't. And what you can control, what the landowner does have some control over, is their land and their decisions to when and how to sell their property. And at eminent domain and prior to, the landowner does have some leverage, their ability to say no to the pipeline, to say no to the first offer, no to the second offer. The ability to say no to the offers they're going to make gives you leverage in and of itself. But regardless, what the way the eminent domain process works, and this is because it's federal, it's a largely uniform procedure. There are some quirks, of course, across state lines and across federal district boundaries, but by and large, because it's federal, they have a lot of similar procedures. And the first procedural requirement would be a good faith offer, and that is the issue, effectively the issuing of an offer before they file suit. My suspicion is that offers on this project are going to come out soon, if not already. And that's just based on my knowledge of how pipelines work. Usually when the pre-filing starts and the application gets closer and closer, the offers start getting closer and closer. So if you don't have an offer yet, I would expect one definitely within the year, maybe even in the next couple months. And what you do with that offer is very important, and we'll get into that. But this offer that they make is a prerequisite to filing a condemnation petition, assuming they eventually get FERC authority. And this is also where our firm gets involved. As soon as you get an offer from the pipeline, you have a case that we can evaluate on your behalf, see if it's a good offer, see if it's not a good offer, give you our thoughts, and go from there. So there's the pre-condemnation offer that needs to be issued. Then there is some level of negotiation. There isn't really much of a requirement that they engage in much negotiation with you. They should, but they don't need to. And then once you've reached the end of your negotiations, whenever that may be, assuming they have their FERC certificate, if a deal cannot be struck, then they will file their condemnation complaint in federal court and take your land for the project. They can use state law if they would like with this federal certificate, but generally speaking, pipelines do not seek and use state process and procedure to condemn land in Texas, especially. So they were very likely to use a federal court proceeding that is less advantageous to the landowners. They have this option, and they will utilize it, of course. And one of those drawbacks to the federal procedure is that there is no guarantee to a jury trial in federal court. You ultimately will likely get a commission, a panel of real estate experts, a panel of judges potentially, or real estate, some combination of legal experts and real estate experts, or you might just get the judge. They might hear your case themselves. It's possible to get a jury trial, but they are very rarely impaneled on these cases because it's a significant process for the court to do that, and they prefer not to generally. So you don't have a guarantee to a jury in federal court, but you do have the ability to say no. You have the ability to get just compensation, which is ultimately what is at the end of eminent domain. And now I want to talk a little bit about negotiations, what we have seen from right-of-way agents. And you're going to be dealing with right-of-way agents in the pre-condemnation process when they issue their offers. They'll be issued by right-of-way agents. These folks are contractors hired by DeLa Pipeline, and their job is to come out and get your land. Their job really is to convince you that what they're offering is a fair amount for your property. It's important to remember, and I'll say this and we'll get into the slide, but when dealing with right-of-way agents, what I tell people generally is to consider where their motivations are, as opposed to maybe other parties. the right-of-way agent will say a lot of things. There's a lot of words that are going to be said to you by the right-of-way agents. But remember, through all those, and some of those words might sound good, I would just caution landowners to remember when you're hearing these words is what is the motivation of this person that I'm talking to? And the motivation of the right-of-way agent is to get your land. It's not to help you out, not to assist you, not to make sure you get a lot of money or that your easement looks good. Their job is to get your land however they need to do that. And that sometimes includes, some tactics that some might consider unsavory. An example would be that, these are some examples of things we've seen from right-of-way agents offering, giving the impression of being generous with their offers by offering 125 or 150% of fair market value, according to who, bonus payments. Again, they try to talk de minimis amounts of money as if, again, they're doing you a favor. We'll give you an extra such amount of dollars if you sign now. That's an effort to make a quick decision, and quick decisions are not great ones in these scenarios. Beyond that, they'll sometimes offer timber crop damages or any sort of land damage that the land might sustain from the construction of the project. These are damages that they would be entitled to, or you would be entitled to anyway, that you should get. So the fact that they offer them up front, as if they're doing you a favor, when in reality, they're just saying, hey, we're going to pay for all the stuff we're about to destroy, which of course they'd be responsible for anyway. And I often tell folks is right-of-way agents love to engage in negotiations that don't benefit, ultimately are, don't benefit the landowner or don't benefit the landowner significantly. An example would be, and we call it a shell game because right-of-way agents like to focus the attention of landowners on things that maybe are important, but aren't as important as other issues. An example would be wanting to quibble with you over price per acre of your land. They offer you some price per acre, and then you respond and say, no, I should get a higher amount of price per acre. And they love having that discussion because usually the discussion over price per acre amounts to $1,000, $2,000, $3,000, $4,000, $5,000 an acre difference. And on a 5-acre easement acquisition, that's a $25,000 discussion at most, which is, of course, is not nothing. But if you're having that discussion, you're also not having the discussion of how does this pipeline impact the rest of the parcel? How does my parcel lose value as a result of the introduction of this pipeline to it? So, and if you're having that discussion, the numbers escalate quite a bit. A 10% impact on a 50-acre tract that's worth $10,000 an acre is $50,000, or and that's using, again, low numbers. If it's a $20,000 tract, you're talking about $100,000. So in this damage to the remainder that I'm talking about that you are entitled to, it's a discussion that right-of-way agents don't want to have because you're having a high-dollar conversation that's out of their authority. They don't have the ability to get to you, even if they wanted to. So it's important to remember to not just and we'll talk about what to do with these right-of-way agents. Just remember whose side they're on, whose side you're on, and what are they telling you, and why are they telling you this? Ultimately, if you're not sure if it's a good offer or not, you have the option to just contact me and send me your offer. And I'm happy to take a look at it for free and give you my thoughts. And you can decide what you'd like to do after that. So I want to talk about what to do when you receive an offer from the right-of-way agent. What I tell folks is to always insist on communication via email only. And I didn't mention on the last slide, but there was a point about verbal offers. I've seen one common tactic we see from right-of-way agents is issuing verbal offers that, of course, can't be proven because they're not on writing and there's no memorialization of it. Verbal offers aren't worth the paper they're written on, as the old saying goes. And so what I tell folks is to avoid this type of gray area where they're making offers that may or may not actually exist. They're telling you that they're going to change the easement, but it's not necessarily represented in that easement. You can avoid all that by insisting on email communication only. And in fact, what I tell people is as soon as you get an offer, you should respond to the right-of-way agent and say, thank you, I will review this and get back to you in a week. I say this is an easy response to issue to a right-of-way agent for a couple of reasons. It gives you time, gives you a week to get your bearings, to evaluate the offer, see what you're looking at, get an attorney to look at it, get somebody to look at it, and then you can respond in a week. They're not going to rush to they're not going to rush to court and file a condemnation complaint against you in a week. But you're not blowing them off. You're giving yourself enough time to respond, and they will follow up certainly in a week. But they're also not bugging you. It gives you a little time to breathe and focus on your strategy. And then in the interim, you can contact an attorney or do your due diligence and then respond. I would avoid in-person discussions. They can't help you. They can only hurt. Everything should be down in writing in email, texts, letters, faxes, anything where there's a writing. I recommend. Here's what not to do when you receive an offer from the right-of-way agent. Do not just jump into negotiations. I think for a lot of folks, the instinct is to immediately start negotiating with right-of-way agents and they issue an offer, you issue a counter, so on and so forth. The reality is you don't know what you're entitled to. And you might think you're getting a good deal, but you might not know if you're getting a good deal. And you can't be expected to know if you're getting a good deal. You don't generally know what these things go for. Knowing the market, knowing what pipeline easements sell for in certain situations, that's incredibly valuable. And knowing what the pipeline is willing to pay is also valuable. And the folks that have that information, therefore, can be valuable to you. What is not valuable is jumping into negotiations without talking to those folks first. Because again, you might get in a situation where you're negotiating, you don't even know what you're negotiating. And you're negotiating over money that you think looks right, but you're not focusing on the easement. And then the money maybe didn't include a very important aspect of your parcel that you're not getting paid for. What if you're leaving money on the table? What if you go too far and you end up at eminent domain and you issue such a high counter that they don't even want to deal with you anymore, and then you're stuck in court and you don't want to be. These are all to say to not jump into negotiations without talking to somebody first. Don't have verbal discussions. Do not take right-of-way agents' promises or verbal statements at face value. If they want to make their promises, have them put it in an email and send it to you. Do not assume their interests are your interests. They are not. And at the end of the day, also, do not make a rush decision. People like to jump into a quick decision here. And usually that's a bad one. Finally, don't ignore it altogether. A lot of folks ignore these cases. They don't want to deal with it. They don't want it to happen. So they ignore it altogether. They put it to the side and they go on with their life. That's a bad decision. That's a bad move. You're putting this to the side and ignoring it is just going to make your problems more complicated, potentially. So it'd be better to focus on it, get some help, and know what you're going to do and respond. And then finally, I want to talk about what they want from you, and what it needs to include. So what they want from you is an easement. A lot of people don't know what an easement is. A lot of people do know what an easement is. We're just going to say what it is, though, because a lot of people don't. An easement is effectively a deed that you're selling to an entity, in this case, a pipeline, but you're not unlike a normal deed where you deed, a house to your neighbor or whoever wants to buy it. You deed the whole thing. An easement is a conveyance that only sells the right to do what the easement says, where the easement says, when the easement permits it. Generally, it is the right to do a certain thing in a certain area of the property for some period of time. And that's obviously very broad, but ultimately it answers the question of I get the most is, what is the pipeline allowed to do? What am I allowed to do? When am I allowed to do it? When are they allowed to do it? Where are they allowed? It answers all of those questions because those details need to be in the easement, and they need to be spelled out clearly in the easement. When they can build, where, when, so on and so forth. Those questions are answered by what the easement looks like. It all depends on what the easement says. People call me all the time and they ask me the pipeline can do this or they can do that. Can they build a pipeline 10 feet from my house? Can they build a pipeline through my house? Can they do this? Can they do that? My answer is, if the easement allows them to do it, then they can do it. And which means the easement becomes an incredibly important document. It becomes the most important document. It defines the rights of the parties to the area on their property. Needless to say, the easements that we see on these projects are largely poorly written. They are not drafted very well. They are certainly not drafted with the landowner's interest in mind, generally. And it's important as a landowner that you focus on this document, and then you make sure that what they say it says actually says that, and then some. Some examples of easements that are poorly drafted and some clauses that pipelines and power lines will sneak into them. They will include unfettered access across the easement, no matter, meaning it covers the entirety of the easement and they can access the easement wherever they want, not just at the public roads or the easement itself. I've seen easements without clauses for future damages and crop losses. I've seen easements without indemnification language that protects the landowner from, for example, somebody suing the pipeline or something that happened to the pipeline on the easement that was on your land. So, for example, if this thing explodes or floods, if there's not proper indemnification language in the easement, which indemnifies the landowner, holds you harmless. If that language doesn't exist, then you might end up being liable for something that merely happened as part of an easement that you had nothing to do with. And then the biggest one we see is the right to build more power lines, the right to sell the rights, sell the rights within the easement to other utility companies, solar farms, telecommunication line, cable line, etc. These are all kind of ancillary benefits, if you let them have it, DeLa Pipeline, that they get to the easement that they will reap the benefits from. Meaning, a lot of times in the easements, they will say, we just want to build one pipeline right here. That's what they tell you. That's what the project says. That's what they say. If you look at the easement, though, it says they have the right to build this pipeline here, there, wherever they want on the land. And not only that, they have the right to add another and another and another down the road whenever they want without any further compensation for you. And oh yeah, they also added in there the right to sell or sublease the easement to a telecommunication line that has nothing to do with the pipeline. It just gives them a little money and leases out your land that they bought from this easement to other entities, again, without a dime for you. These are just some pitfalls that we have seen on these easements. It's imperative that you have somebody look at this because, and I'll say this finally, easements are forever, unless it's a temporary easement, which those are temporary, of course, but permanent, which perpetual, which will be the one for the pipeline, that lasts forever. And there's no extinguishing unless they extinguish it. So keep that in mind. This will be on the title forever. It doesn't matter if you sell it, your kids inherit it, that easement will be there, and they will inherit that pipeline. They will inherit the easement as well. And then finally, we're getting towards the end of the presentation. So for a complete compensation package, so this is compensation you should receive from the pipeline for this easement. A complete one, what I would consider complete, should include a proper price per acre for the land they're acquiring, a proper payment for any land damages, crop timber, you name it, that they're going to cause, anticipatory, several years of it, depending on the land, payment for anticipated soil or ground damages, or a clause requiring them to properly remediate, proper consideration for all other damages, irrigation, compaction, soil mixing, flooding, etc. That should be included as well. Residual damages, I touched on that earlier, any impact on the parcel that the introduction of the pipeline might have. And that, of course, this is all, of course, in addition to what is offered by the utility as part of the initial offer. And that, with that, I will say, a lot of people at this point are interested or are kind of curious about how attorneys get paid, how our firm gets paid. So I'll just go ahead and jump into that. Attorneys in these cases work on one of two ways: contingency or billable. Largely our cases are contingency, but if you're interested in the billable rate, we can talk about that. Contingency fee is exactly what it sounds like. Our fee is contingent on how much more money we get than what is offered by the pipeline. In this scenario, if you're offered $10,000 and you hire our firm, we get you $50,000 in settlement or judgment. It's a $40,000 difference. Our firm collects a third of the difference, and you end up with the remnant. We do it this way because first, a lot of folks don't want to hire attorneys. They want to come out of pocket to hire attorneys. And in this relationship, our firm only collects a fee at the end of the matter. And also beyond that, it provides peace of mind. We find for our clients that they know that we're doing the right thing and on your side, because of course we're invested. We're partners under this contractual relationship. We have a vested interest as well in making sure that the money is where it needs to be. So that is the end of my presentation, and I will open up to questions if there are any. If you do have any questions, go ahead and put them in the chat or put them in the Q&A right now as I conclude this, so I can answer them when we're done. Next steps, what you should do. As soon as you should receive an offer, you should hire an attorney, or at the very least, contact an attorney. I tell people that the time to vet attorneys is now, before you get the offer. And then when you get the offer, that's when you should be hiring your attorney, if you're going to hire an attorney, of course. Identify your goals, your plans, what you're concerned about, your worries, so that their attorney is ready to go when you hire that attorney. Strengthen numbers if you have a group. If you know a bunch of landowners are affected, your neighbors are affected by this, and you have a group of landowners, usually there is strength in numbers, and groups are able to get better results, able to leverage their group nature ultimately to a better individual compensation package and easement. Ultimately, you have your own case. This is not a class action. Everybody has their own case with their own easement, with their own property. Property is unique, but being part of group, while not necessary, can be definitely good for landowners. It's a positive. And then I will say, before we get into questions, if you have any offers, if you have an offer, as soon as you get an offer, I'm happy to look at it for free. That is my email address, jordan@landownerattorneys.com. You can also text it to my cell phone. You can fax it to that number right there. These are free. I do not bill for that. So if you just want to send it to me, I will look at it, and then I'll get back in touch with you probably within the day, and we can go from there. With that being said, I'm going to go ahead and wrap up my portion of it. If you have questions, feel free to ask them now. Okay, it does not look like there are any questions. So easy enough. Well, thank you everyone for stopping by. I appreciate it. If you do have questions later, give me a call, shoot me an email. Happy to answer any questions you might have, of course, for free. And yeah, thank you for stopping by. I appreciate it, and have a good day.